First of all, I want to ask you this. Is there any difference between a civil partnership and marriage?
Basically, no. Originally, civil partnerships were introduced for same sex couples. I think the intention was always that once marriage was introduced, civil partnership would go by the wayside. And from a personal point of view, I don't hear of many people entering into a civil partnership when they can now marry. But of course, civil partnerships was introduced for opposite sex couples more recently.
Mm,
So there is still the two options,
mhm.
but basically they are one and the same. And if parties divorce or dissolve their civil partnership, the law is basically the same.
So, in the event that the relationship breaks down, the same process is followed, whether you're in a civil partnership or a marriage, in order to bring an end legally to that marriage or civil partnership.
Yes, the main difference is terminology.
Okay.
So if it's a civil partnership, it is dissolved. If
Mm,
it is a marriage, it is divorce.
mm.
And the process is the same. And since April 2022, we've had no fault divorce or dissolution where there's no blame. And it's done relatively simply on the court portal, working through a 20-week cooling off period to then applying for conditional order, which used to be your old decree nisi, and thereafter the final order, which used to be called decree absolute of divorce.
Okay. And I suppose importantly, the first thing to consider would be any arrangements that need to be put in place for the children.
Yes, so children are normally everybody's priority when parties separate. And the only difference between same sex couples may be that there is more of an issue in relation to legal parenthood. And whether they both have parental responsibility. But ultimately, you're trying to look at what is in the child's best interests. And normally that means having a relationship with both parents.
Yeah.
And if the parents can't deal with that themselves, then start thinking about alternatives like mediation.
Mhm.
Ultimately, an application can be made to the court, but this should always be considered as a last resort.
I suppose it follows from that that when the parents are living separately and there are separate homes and the children are living in two homes and being parented by both of their parents, we need to look at the financial implications of that as well. So the court will always look at the financial implications if there is a divorce or a dissolution of civil partnership. And how does that work?
The starting point normally is for there to be financial disclosure, because until you actually know what the assets are, the income is, then you can't make a decision on what the options are. The court's priority will always be a home for children. And they can take it can take some looking at, particularly if children are based with both parents, or if children are in a shared care arrangement, then both parents want the same accommodation. They both need somewhere to live. And a lot of the time, I always say one into two doesn't go.
Mm.
And you're trying to divide that as best you can. And the courts normally start on the premise that there should be equality of matrimonial assets, and then look to see how they can achieve that and whether both parties' needs are then met. But the thought at the end of the day is always to try and achieve a clean break settlement.
Mhm.
And achieving a clean break settlement means that there is no ongoing financial link between the parties, perhaps other than child maintenance. So both parties can move forward with their lives without having somebody else there pulling strings or getting involved in matters.
So let's assume we've been able to acquire two homes and there may be some child maintenance being paid, but underneath all of that, there is an aspiration that there'll be a clean break. When do pensions fall to be considered?
Well, pensions come into the whole financial disclosure. And pensions are very important assets because sometimes they are the biggest asset, even over and above the matrimonial home. So pensions are looked at on the basis that they've accrued during the relationship. And there's three main things a court can do with pensions. Pension attachment order is something we don't deal with as much as we used to. But now we have what we call pension sharing orders. And that is where the court can make an order where somebody's pension is shared. And that might be on the basis that they are both put in the same position with regards to pension income upon retirement. The
Mhm.
alternative, and one that is used a lot, is what we call an offsetting order. And that's whereby one party, for example, the one with the lesser pension, may receive greater capital now instead of having a share of the pension. So there is an offset, there is a value to that pension, and perhaps because one party needs more than 50% to rehouse themselves for whatever reason, they may therefore receive more capital now, but a smaller share of the pension.
Okay. So we've dealt with housing, we've dealt with clean break where possible, pensions. Is there anything else that you want to add, or what would your final piece of advice
I
be?
suppose the only other matter the court will look at is spousal maintenance and whether there should be spousal maintenance, which is based on needs. But again, the court very much have this view of looking at a clean break settlement.
Yeah.
So if it is a case for spousal maintenance, is it possible for that spousal maintenance to be capitalised so that the lower earning party receives a greater share of the capital now instead of spousal maintenance. So you can then have a true clean break on both capital and spousal maintenance.
And again, how are these issues resolved between a couple who are going through separation? Is it sensible that they come immediately for legal advice, would you say? Or do they have to consider other options?
I think the key is to get legal advice early on.
Mhm.
If you can resolve issues between yourselves, then great. Have that conversation. But it's good to get the legal advice beforehand. But then there are other options. There's the option of mediation. There's the option of what we call collaborative law, whereby solicitors who are collaboratively trained will try and help the parties to reach an agreement, which is all done round a table with legal advice out in the open. Ultimately, if the parties can't reach an agreement, then there may need to be an application to court. But from my point of view, that has to be a last resort, given costs involved, the time scale, and the fact that they may both end up with something they don't want.
Okay. So I think ideally you would advocate that it's sensible for the couple who are separating to try and narrow the issues, take advice early on. If there is an option of resolving any issues through mediation or collaborative law, to look at those options. And finally, as a measure of last resort, there has to be an application to court.
I think that's the case, yes. Court has to be a last resort, and there are a lot of other options, and a lot of solicitors are resolution trained and are wanting to look at matters to deal with it as quickly and amicably as possible. And just because parties instruct a solicitor each doesn't have to straight away be acrimonious. Parties can still agree a way forward with financial disclosure and then start to, as you say, narrow the issues and try and work towards an agreement.
Thanks.